I'm going to have to learn that technique. That was a lot of really great content on just one slide. I have a tendency to have too many slides, but hopefully not too many this time. So I'm Deven McGraw. Up until about a year ago, I was the HIPAA regulator here in DC, but I am now with a health technology startup company called Ciitizen out in California. So that's really my sole disclosure. It's essentially in my bio. I'm the Chief Regulatory Officer and General Counsel there. We are trying to build a platform that will enable patients who are very sick, starting with patients with cancer, to be able to collect and use and share all of their data, both to help them and also to help others. I'm going to talk about governance and privacy. Governance is obviously a very big issue. Oftentimes, in the case of data, we think about the issue of governance almost solely through the privacy lens, at least from a sort of legal obligation standpoint. It's not, I don't think, a good idea to do this. I actually was really moved by the presentations by Dr. Farriman and Dr. Joseph earlier about certain fairness, justice, and LC considerations that really ought to be part of what we think about in terms of governance, but they're not well represented in privacy laws. Privacy is my area of expertise. I'll talk about that. I'll leave to David Magnus all the other good stuff. Why do we care about privacy? Why is privacy important? Why should we not think of privacy as just a check-the-box exercise in terms of being able to use data? And it's because there is a population of people for whom assuring them that their data will be kept confidential is really essential to them going into getting care in the first place. They have fears about how that data might be used against them. And there's some statistics on the slide, and often in the mental health case, this becomes the most acute. But it is also true in the cancer space as well, particularly where people have concerns about what this might mean for their future employment or their ability to get insurance down the road, particularly given uncertainties about some of the commitments that we have in the law with respect to pre-existing conditions remaining in place in the near future. But the aim of privacy and security, frankly, is not so that the data can be in this nice little locked box and no one can have it. Privacy is about enabling appropriate use of data. And it's really about really good data and responsible data stewardship. The Fair Information Practice Principles, which were essentially first articulated by the Department of Health, Education, and Welfare way back in the 70s, but for which there are multiple international articulations of those principles today, they are really the foundation for all privacy law that exists both here in the U.S. and abroad. And informed consent and assuring autonomous choice on the part of the individual with respect to their health information is a key principle, but it is not the only one, and it's often not necessarily the most important one, particularly given that consent is often difficult to obtain or impracticable when you're talking about retrospective research for large data sets, for example. So there are others. Transparency with individuals about how their data are used on an ongoing basis, not necessarily just at the point of data collection. Data minimization. We often talk about de-identification or anonymization of data as a tool of regulatory management, but in fact, it's part of fair information practice principles that you use only that data that you need in order to accomplish a legitimate purpose. And oftentimes, masking, stripping identifiers is a way to minimize and reduce privacy risk while still maintaining the utility of data. Security safeguards help make sure that the commitments that you're making to people about who can see their data and for what purposes can actually be honored. And accountability, whether that's regulatory accountability or whether that is accountability in an internal, from an internal perspective in terms of, sort of constant vigilance within institutions, within collaborations to make sure that people are fulfilling the commitments that they have made to be, say, part of a data collaboration. So how do we govern health research uses of data? Well, there is a heavy reliance, frankly, on de-identification or anonymization of data. Lots of discussion about HIPAA-compliant data set, with the assumption being that it has been de-identified in some way in accordance with HIPAA standards. Again, this is consistent with data minimization, but I oftentimes think that people seek this sort of holy grail of meeting the HIPAA standards around de-identification because of the relief from regulatory obligation that comes along with that de-identified data set. You are able to share it more freely because it is, at least from a HIPAA standpoint, it really falls out of regulation. Otherwise, you may have consent required. I realized after I was going over these slides that I completely forgot about the ability to seek waivers of consent in certain cases, both under, at least in U.S. law, both under the common rule as well as in HIPAA. So that is still good law. The absence of it on the slide does not mean that has gone away. But I have found in the years that I've been doing this that does get used for certain types of research, again, retrospective research on large data sets. But for the most part, people have gravitated, again, towards the anonymization pathway in order to allow data sets to be more liberally used. There also has been some movement, at least here in the US, to allow individuals to provide some more generalized consent for use of information about them for future research purposes without the need to sort of specify upfront the very specific research projects where those data will be used. And that's been true at least in recent HIPAA guidance and also with respect to some more recent common rule changes. Privacy law is really experiencing some quite cataclysmic changes. And we're going to focus on a couple, but I promise you, without diving into the details, these are very complicated regulatory regimes, and we could literally spend days talking about each of them. One is the Global Data Protection Regulation in Europe, which is already in effect, went into effect in May. And the other is a more recent development that has a lot of people quite nervous, and that was the passage in California of what's called the California Consumer Protection Act, or CCPA, or CACPA, depending on which acronym you like. The trend in this legislation, there are a couple of trends that I think are worth noting. One is a trend toward requiring more explicit, specific consent from individuals before their data can be used. These are still regimes that also apply to identifiable data. But as I'm going to talk about it in a minute, I'm preempting my slide here, the conditions under which data are considered to be no longer personal data or identifiable data, or that are de-identified or anonymized, are getting more rigorous and strict under new regulatory regimes. But there is this trend towards explicit consent. There appears to be, so for example, in the GDPR, a recognition that you really can't do that in a medical research context, and we need to allow some research to be conducted either under more generalized forms of consent or through other tools such as pseudonymization, coding of data, which again provides some protections for privacy. But even in these discussions around allowing more general consents in a regime that is moving towards requiring things to be more explicit, there's still a lot of sort of very nebulous and language around needing those consents to have sufficient detail in order to inform people. Well, what does that mean? I think that's really hard for folks to operationalize. When are you giving people enough information that it's sufficient to allow them to consent to future uses, but without overwhelming them, frankly, because we know from lots of research that people don't fully understand informed consent processes or documents, and the longer we make them, the worse, the lower the level of comprehension. At the same time, the legal expectation is, well, if you don't want to go gather consent on this explicit express basis, you better give people enough information to sort of, so that they really understand on some level what they're consenting to. It is a very tough nut to crack. Again, broadening of the definition of identifiable or personal data is also a trend, as well as broadening the actors who are subject to these laws. And then also increasing individual rights with respect to data, probably even those of you who are not steeped in what is covered under the Global Data Protection Regulation or what some of the various provisions are, have probably heard about the right to be forgotten, which got a huge amount of press and is continuing to get a huge amount of press. So I have a few slides on GDPR. Again, we are not going to go into excruciating detail on this, I promise. It basically applies to data controllers and processors, so it's not sector regulation. It's not, people, unlike HIPAA, which says, if you're a healthcare provider or a health plan, you're covered. GDPR is much more of a data protection law. If you are controlling personal data or you're processing personal data, you're going to be looped into coverage, but it's not limited to entities who just operate in the European Union. If you are gathering data on a person who lives in the EU, you are covered by this law. So it has really, the reach of the law got bigger than just entities who have an office in the EU. And so it's really quite relevant to a number of US companies. Applies to personal data, doesn't apply to data made public by the subject, doesn't apply to data from individuals no longer living. That's much more characteristic of data protection laws generally, is that they don't apply to people post-death. HIPAA, of course, is the exception to that rule. Here is the definition of personal data. And as you can see, it's quite broad. Relating to an identified or identifiable natural person. An identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, an identification number, location data, an online identifier, or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. This is broad. So there's no definition of de-identified data in GDPR. Basically, if you can somehow fall out of that definition of personal data, then you are falling out of protections of GDPR because it applies to personal data. And so from one commentator, it said, well, data is not personal data only if there's no reasonable means through which someone who has access to the data could use the data to re-identify an individual who is the subject of that data. So it's generally believed this is a higher standard than HIPAA. I think we just don't know enough about how this law is being interpreted by regulatory authorities to know for sure that that's the case, but that's the general scuttlebutt among privacy people who do privacy and compliance work within institutions who hold personal data. All processing, or as they like to say, processing, must be lawful, and the assumption is, again, that consent is going to be required unless you have another lawful reason for processing it. This is actually the framework of HIPAA, but there's so many ways that you can use data without needing to ask consent under HIPAA that it sort of doesn't look like a regime built on consent with exceptions. GDPR looks much more like a consent law with some exceptions. But one of the most important ones is, I don't know, this one at the bottom, which is necessary for scientific research, subject to appropriate safeguards. And what I've been able to read from the working papers that were created prior to this law going into effect is that there is an expectation of pseudonymization as a best practice for falling into that category there, to be able to process data without necessarily having to go back and to get consent. But it's something, again, to keep an eye on because this is a very confusing space and the law just went into effect and we don't have any enforcement history on it yet. I'm not going to go over this slide. Please don't take a picture of it. I'm making this available to you all. I made a comparison of the individual rights provisions between what HIPAA guarantees to people here in the US with respect to the right of individuals, such as the right of patients to be able to get their own data, is as strong, or if not stronger, in GDPR, because GDPR says not only do individuals have the right to copies of that data, they have the right for those copies to be portable. What a concept. We haven't quite reached that here in the US. The California Consumer Protection Act passed over the summer, technically goes into effect January 1st, 2020. It was passed very rapidly in order to avoid a ballot initiative that was going to be much more stringent or difficult, depending on, or great, depending on who you ask, in terms of their opinions about the law. It going into effect, the legislature had to act very quickly. They are continuing to try to tinker with the law in order to address issues that are inevitable when you try to draft and pass something in a very short period of time. It applies to a business. So this is definitely limited to for-profit entities, and it's limited to for-profit entities that are large or who collect a lot of data on California residents. So you don't have to be physically located in the state of California as a company in order to be swept into this law. I think the last estimate that I saw is that 1/6 of the population of the United States, 1/6, lives in the state of California. So there is a lot of entities who are large enough to meet some of these criteria who are going to be swept into potentially having to comply with this. And it has, again, this incredibly broad definition of what constitutes personal information. Had to put it on 2 slides. It was so long. Includes biometric information as a sort of presumed identifier, and so therefore, if existing in your data set, it qualifies as personal information, as well as inferences drawn from any of the information identified above to create a profile on someone. This is, again, as you much more sort of geared toward commercial Facebook, Google-like ways that they use data, but they've carved out some healthcare activities, but not all of them. And I'll get to that in a second. Here's the definition of de-identified data. Again, these slides will be available to folks. I urge you to explore this in a lot more detail. This is not intended to be legal advice that you can just take home and install or instantiate in your organizations, but it is something to keep an eye on and to understand what it means for you all. It is believed to be stricter, again, than HIPAA and the common rules. So the notion that we can rely on HIPAA as our de-identification standard for health data is in some doubt, at least with respect to global research, as well as, again, how CCPA is going to get operationalized by the Attorney General in California. Here are exemptions for healthcare entities. They are oddly worded. Again, still lots and lots of privacy professionals trying to unpack what all of this means. Probably one of the most relevant ones is C, information collected as part of a clinical trial that's subject either to the common rule or to the FDA rules or to the good clinical practice guidelines issued by the International Council for Harmonization. That's information that doesn't constitute personal information, and therefore, even if you were a company that might be subject to the CCPA jurisdiction, the information that's part of a clinical trial is not going to be regulated by the CCPA. Having said that, that's not a wholesale research exemption, medical research exemption, right? That's a clinical trial exception. There are a few other exceptions for entities covered by HIPAA and entities covered by with respect to PHI, protected health information. Note that if you de-identify data in accordance with HIPAA, that's no longer PHI, so you actually can't take advantage of that exception because it applies to PHI and not de-identified data. It's not an entity-wide exception. And then there's the California Medical Information Act, which is essentially California's version of HIPAA. Similarly, if you happen to not be swept up into the HIPAA exception, you might have one with respect to the medical information that you gather as an entity subject to the CMIA. So I wasn't kidding when I said it got a lot more confusing. It really does cause us to think about what do we do now in terms of making data sets more widely, responsibly available to people? Do we do more to get consent? Can we still reliably do de-identification? Are U.S. lawmakers going to come out with something else because a lot of entities who know they're covered by CCPA are urging Congress today, right now, to pass something that would be federally preemptive of the California law? We don't know where that's going. What's going to be the impact of all of this, both in terms of what we do today to share data, but also what we're trying to do at Ciitizen and other companies are trying to do in terms of empowering individuals to be able to collect and share their data. And I'm out of time, so I will stop. Thank you.